who owns and will own our digital data? Or rather, who has which kind of legal entitlements to control which data today and tomorrow? Well, it is my preliminary conviction that some steps are already being taken to tackle this issue in the EU, and that the inevitable solution is to step back from the concept of exclusive ownership or intellectual property rights and to focus on the potential of a variety of different rights instead. Now, it has long been debated whether there are or should be classic ownership rights or intellectual property rights in digital data, a broad term that includes so-called big data, but equally your text files, your emails, and so on. This issue is very relevant. A vast amount of data is created, about 59 trillion gigabytes in 2020, for instance. So it is important for various economic actors to know whether some of that data is part of their assets, whether they can be resold, licensed, or given as a security, whether they are part of an estate at the moment of death or bankruptcy, and so on. Now, long story short, although some states seem more favorable towards the idea of data ownership or data intellectual property, um, there seems to be a fairly large consensus that creating exclusive rights with erga omnes effects is not the way forward for data. Such rights would hurt freedom of expression, overlap with existing IP rights, and does not add up with the homogeneous variety of data available on the market. More fundamentally still, entitling certain actors with legal exclusivity would run against the very nature of data as a non-rival commodity. That is, something that can be used by many people at the same time without being consumed. Now, because of that non-rival characteristic of digital data, I believe that the question of legal control in data will always require a case-by-case detour through existing rights. And these rights can either be contractual rights, IP rights, property rights, or statutory access rights, which are increasingly created. Now, let me explain. How do we determine who controls certain data today? Now, if a set of data is saved on the hard disk of a PC, then arguably the owner of that PC can use their ownership rights to practically exclude others from accessing that data on that PC. They may not be the legal owner of that data, but they can use their ownership to deny access. Similarly, certain data may incorporate subject matter of an IP right. Think of a Word file that embeds a work of authorship. Well, although an author cannot claim actual ownership in that file, copyright law does allow them to control that file in their capacity as a right holder, for instance, by excluding third parties from making reproductions. Now then, what if one saves or uploads non-IP protected data on the servers of a cloud provider? Well, by lack of an erga omnes right in data, the legal status of this data will simply depend on the contract between the uploader and the cloud provider. So, to date, a case-by-case analysis of each agreement will, in principle, be necessary to determine parties' entitlements in data if there are no physical ownership forms or IP rights to turn to. Now, needless to say that the rights of the uploader might be very limited if the cloud provider has a better bargaining position. But is that all? Well, I don't think so, because there seems to be a kind of recent legislative trend to create specific access rights to data to the benefit of specific actors. In 2013, for instance, the Luxembourg legislator has introduced a right to revindicate so-called incorporeal movables from bankrupt undertakings. This right is used, for instance, to claim back digital data in insolvency proceedings. Then there's the GDPR, which confers a free but conditional right upon every natural person to receive all data that they have provided to a controller, and which is personal data in the sense that it allows their identification. Introduced to prevent lock-in effects with social media platforms, this portability right was meant to allow individuals to easily transfer their data to a new service provider. Although many of its modalities still remain unsure, its scope is broader than that though. It entitles us to receive all our emails from Gmail or Outlook, for instance. In French consumer law, a similar provision used to allow consumers more generally to claim back all data that they had provided to electronic communication providers. More recently, then, we've seen that the European legislator enacted this provision in the Digital Content Directive, a directive which more or less extends the conformity rules for consumer sales to the supply of digital content to consumers. Now, in that directive, consumers get a free right to access all digital content that they had provided or created while using the digital content or service supplied by a professional party. This right is reserved to B2C contracts and can only be invoked when the contract is terminated for a major lack of conformity. All these cases are examples of specific portability rights or rights to access certain data. They all have limited, targeted scopes, and they were created with specific objectives in mind: the protection of creditors, protection against lock-in, and so on. However, what does the future hold? Well, since half a decade, the European Commission is working on the establishment of a digital single market. Now, famously, copyright was reformed as a part thereof. Another pillar of that DSM strategy is creating a framework for the data economy. Now, in this respect, the Juncker Commission first alluded on the creation of IP-like data creators' rights, but changed its position after stakeholder consultations. In December 2019, Juncker made place for von der Leyen, and in February 2020, the Commission launched its program, the European Data Strategy, touching on different policy topics. And in execution thereof, they have later proposed, among others, a Digital Services and a Digital Markets Act. Now, in the last quarter of this year, they will also present their proposal for a Data Act. In this respect, a public consultation was held from 3 June to the 3rd of September. And here I have to make a small disclaimer, that is that the presentation which you are currently watching was prepared for you before the Commission issued its proposal for a Data Act. So what comes next is based on the Commission's prior communication. Now, that being said, what might be in this Data Act that is relevant for us? Well, two so-called data strategies: data sharing and data portability. On the one hand, companies and individuals need to share more data, the Commission says. So it is considering creating user rights for non-personal data created by multiple actors, for instance, data stemming from the Internet of Things, creating duties and enhancing tools like smart contracts for businesses to share data, and revisiting the database and trade secret directives. Second, the Commission argues that the portability right in the GDPR, which I just mentioned, has untapped potential and could serve as an inspiration to increase citizens' autonomy on data. So, for instance, a portability right for professional users of cloud services is on the table. Now, we'll see how all this will be operationalized, but it might just be that the Commission will propose new rights to control, access, or revindicate certain data, perhaps with broader scopes. So, returning to what I said, to claim control over data, one will inevitably always need to find a right to attach oneself to. And when physical property rights IP rights and contractual rights fail to form a solid ground, then the currently enacted and future statutory access rights might just do the trick and allow us to control data. So in the next phase, one could think about questions like how these statutory rights can be transferred, licensed, validated in the books, and whether it is or should be possible to encumber them with a security and so on. One important difference between these statutory access rights and ownership and IP rights will probably always remain, though, that is that these access rights cannot guarantee exclusive control or access. However, if you accept that exclusive rights in data are not only undesirable, but also irreconcilable with the very nature of digital data, then do these access rights really differ so much from what ownership in data would look like? Indeed, it seems that for those attributes that are compatible with data, different categories of rights will be, and already are, taking over the functions of ownership rights. Ladies and gentlemen, thank you for your attention.